Good day, Crime Talk aficionados. We have a great show for you today, so let's get to it. That's right. Ada County says, hey, we've got this. We'll handle it when it comes to the Brian Kohberger matter. All the people that said crazy things and people were told, how dare you say such things about Sean? Did he do it? Combs? Well, all that sounds a lot more believable. We'll give you an example. A Kentucky sheriff kills a judge in his chambers and then immediately surrenders. Sarah Boone says stuffing her boyfriend into a suitcase was no accident. It was self-defense, obviously. Karen Reed gets the ear of the judges on the highest court in Massachusetts. And is this a case of actual innocence or just a desperate attempt to stop an execution in South Carolina tonight? And I'll give you an example of how not to treat your roommate, but I think there's a little more going on. We have This Day in Legal History and then our Dumb Criminal of the Day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do. Leave me a comment below. Hit that little bell. And remember, you can listen to us anytime on any of your favorite podcasting apps. And yes, please go to crimetalksearch.com. Sign up for that background subscription service. We use this literally every day here in the office because guess what? You can do a background search on just about anyone here in the United States, and you're going to get a report while you wait. And that report is going to be emailed to you, and it's going to have everything you want to know about the person that you are looking into. So if somebody new is coming into your life, go check them out. crimetalksearch.com. All right, let's go ahead and open the record for September 20th, 2024. And first on the docket, Ada County. They're saying, we've got this. Don't worry about it, old Latah County. So all hearings scheduled in Latah County for the case of Brian Kohberger are apparently going to need to be rescheduled there in Ada County. And that's according to kind of the administrative judge that was speaking about the Kohberger case. So basically what that means is the trial timeline could change. They usually don't move them up forward. They usually push them out a little farther, ladies and gentlemen, so we'll have to wait and see. So the judge noted that all the time schedules that were laid out in Latah County will have to be reset. And guess what? That's what they're going to do at the status conference next week when Judge Hippler, who is assigned to the case, will determine whether the parties, including the prosecution and the defense, can come to the hearing virtually. Now, it's a chance for the Judge Hippler, and the counsel involved to find direction for moving forward and moving the case towards the ultimate trial that everybody anticipates. Anyway, Ada County will also handle all resources for the trial from here on out, and they'll have no help from outside counties. The judge noted that the Ada County Courthouse is used to rearranging on a daily basis, so he expects business to go on as usual even during the trial. He basically said didn't really think there's going to be any delay or put off this trial far into the future because we can handle this trial. The judge noted this isn't the first time that Ada County has dealt with high-profile cases. As you know, both Lori Vallow and Chad Daybell cases were held there, and they are prepared and ready. They said they're going to be working with all their partners, such as the sheriff's office and the county commissioners and other courts, to be able to put on a fair trial, and said that a trial that is there to protect the constitutional rights that Mr. Kohberger has, and a trial that protects the constitutional statutory rights that the families and the victims have. There you go. I've said this once and I'll say it again. Larger jurisdictions can handle these types of cases because they are frankly routine in these larger jurisdictions. Apparently in Ada County, no big deal scheduling a 6 to 8 week trial. I can tell you I was in court today. I'm like, why are there so many potential jurors out there today? Well, they got a potential serial rapist case that is going to be starting on Monday. They're pre-screening all the jurors today, but that trial is expected to go for some 6 weeks with some, I think, 14 to 16 victims. And everyone's acting like it's no big deal. We'll just deal with it. You get into those smaller jurisdictions, not as easy to do that. Well, we do know that the judge has issued an order covering decorum. And the significance of this is, well, will the trial be televised or not? So the court there in Ada County has issued a new decorum order, and it's very similar to the decorum orders that we saw in the Lori Vallow and Chad Daybell cases. And the court notes that they're mindful of the need to balance the constitutional rights of Mr. Kohberger, the public's interest and right to information in conjunction with certain constitutional and statutory rights for the public to attend the various proceedings. And the court appreciates the interest in maintaining order and environment, which permits all the participants to focus on their responsibilities without undue distractions. And the courts has the interest in the safety of the public and the court security personnel at heart as well. So, as it relates to seating may be reserved by the court for designated individuals, including but not limited to authorized court personnel, security personnel, the defendant's family, victim's family, and others specified by the presiding judge. Public seating, subject to the need for reserved seating in as previously discussed, they will do their best to have public seating. There will be no priority or designated seating for the media. No person may reserve seats except as designated above in the order. And standing in the courtroom when the seating is unavailable will not be allowed. All spectators, including members of the media and the public, shall be seated before court is in session and during any portion of the hearing, and no entry or re-entry to the courtroom shall be permitted while the court is in session. Cell phones, tablets, laptops, or other electronic devices shall be turned off or be in silent mode and shall not make any sound or create any distraction, and devices shall not be used to record, photograph, or transmit any sounds, images, or video from the courtroom. No one may talk on a cell phone inside the courtroom, and if the use of electronic devices such as keyboards are distracting, their use may be prohibited by the presiding judge. If there's any activity or behavior which is considered disruptive, that will result in removal from the courtroom. Hearings are open to the public, and they are currently now scheduled to be live streamed. However, if the streaming of trial is permitted or any sort of broadcasting of the jury trial, that will be addressed in a future order. And any prior orders relating to the broadcasting of the jury trial in this case is hereby rescinded, the judge says, and any person violating the terms of any portion of this order may be removed or permanently excluded from the courtroom. So there you go, ladies and gentlemen. I think the judge is going to be moving this case along swiftly. I hope that they can keep the trial date for June of next year like anticipated, but we'll have to wait and see. But it sounds like Ada County is moving this case along. As you noticed in Latah County, nothing against anyone in Latah County or the judge or anybody like that, but it just always seemed like it was not well planned, not well executed, and everybody always seems to be scheduling, and it was just chaos. And I understand the judge is busy, everyone's busy, this is a big case. They made the right choice, sending it to a larger jurisdiction where this can be handled. They have the resources, and they can move this case along. All right, some news on old Sean Diddy. Like I mentioned, all these people that made accusations against Sean Combs, well, now they all seem a little more believable, don't they? Yes, they do. So let's give you an update on Sean Did He Do It Combs, or Sean He Did It Combs. He's now on suicide watch. Now, the suicide watch is apparently normal when you have a high-profile defendant, and they obviously don't want someone to harm him in general population. But, you know, you got to be careful, right? You got to be careful. There was that other guy at that Manhattan detention center. What was his name? Oh, that guy named Jeff. Where when everybody was saying they're walking around, looking at the high-risk people, suicide watch people, they actually committed suicide, apparently. So we got to look out for that. But there is now a video, and I remember when this video came out and didn't think anything of it. Or maybe I saw it when the homes of Sean Combs were raided. But there was a video of this guy. He apparently held himself out as a porn star, and he claims that he was Sean Combs' sex slave. That video is once again making its way around the internet. Now, should Sean Combs want to be on suicide watch? Well, you got a lot of people coming out of the woodworks, and he was denied bail. There's not really a whole lot you can do to appeal at this point. Yes, you can you appeal the magistrate's decision, It's an abuse of discretion standard. It goes to the district court judge who looks at it and says, yeah, nope, there's plenty of reason to keep it here. Yes, they can appeal to the appellate circuit, Second Circuit in this particular case, and see if they can get some relief there, but very unlikely simply for the fact that, it's an abuse of discretion standard. I don't know what you can say. I don't think he's going to get out. So like I said, Combs was denied bail even though he offered to put up his home, which is worth about $50 million if you include his mother. So a newly resurfaced video shows an ex-porn star who was arrested in 2018 for allegedly shooting up one of former President Donald Trump's Florida golf courses. And he was telling police during this interrogation that he was allegedly Sean Diddy Combs' sex slave. Now, the year-old clip of Jonathan Oddi, O-D-D-I, being grilled by the Miami investigators in this unrelated case reemerged just days after Combs pled not guilty in New York to sex trafficking and racketeering charges. Now, his arrest comes years after Oddi, a former stripper and porn star, was filmed bizarrely claiming to the police that he had sex with Combs and the rapper's ex-girlfriend, Cassie Ventura. He said, quote, "I had sex with Cassie and Sean," he says, and he would pleasure himself and tell me what to do, referring to Combs to do to his girlfriend, Cassie. And he said, "I was like a sex slave for them, and I did whatever they wanted." Now, Mr. Oddi claims that he caught herpes during the alleged freak fest with Mr. Combs and Ventura, and that he had taken liquid cocaine with both of them. Now, his bizarre allegations were never really investigated or substantiated. They were simply dismissed by police officers. However, they bear a resemblance to claims detailed in Combs' recent indictment, as well as those Ventura laid out in her federal lawsuit that she filed against the rapper last November, in which she accused him of a year-long pattern of domestic and sexual violence. Now, Mr. Oddi is remaining in custody in Miami-Dade on attempted murder of law enforcement officers, armed burglary, and armed grand theft charges over the 2018 incident. Like I said, meanwhile, Mr. Combs is being held without bail at the Federal Metropolitan Detention Center there in Brooklyn, pending trial. And we will bring the lurid details to you as they become available. When the home was raided, it was interesting because there were lots of people that said that there's more to this than what people were doing. But they said, no, it'll never happen because he is protected. He's got all these pictures with all these famous people. And I'm not talking about, you get your, quick picture with the celebrity or famous politician and you move on next in line. This is like people in Hollywood, a lot of people in Hollywood hanging out with Sean Combs, and not just for a quick picture. Next on the docket, the Kentucky State Police and the Letcher County coroner were still at the courthouse yesterday after 5 p.m. investigating the shooting death of the Letcher District Judge Kevin D. Mullins, apparently shot by the county sheriff. That's right, the elected sheriff. Now, officials say that Sheriff Mickey Steins was arrested after surrendering himself to the police. The shooting occurred in the judge's chambers about 3 p.m. Yesterday afternoon, and the police had obviously the area cordoned off for the safety of everybody, but apparently the sheriff walked out, hands up, and said, "Arrest me." Now, Steins allegedly walked into the judge's outer office, told the court employee that was there and others gathered around that he needed to speak with the judge alone. The two then went into the inner office, closed the door, and those outside heard the shots. Steins walks out with his hands up and surrenders to the police. Steins was then handcuffed in the foyer of the courthouse, and officials expected the investigation to continue for several more days. Now, the lead prosecutor there in the county describes there's been an outpouring of sympathy, and he has recused himself from the office or having anything to do with it, citing a conflict of interest because there's family ties to Mullins. The prosecutor says, "We all know each other here. Anyone from Letcher County would tell you that, but Judge Mullins and I married sisters, and that we have children who are first cousins but act like siblings. For that reason, he is taking steps to recuse himself and his entire office from this investigation. Now, Mullins was appointed to be a judge back in 2009. He oversaw juvenile matters, city and county ordinance matters, misdemeanors, traffic offenses, arraignments, felony probable cause hearings, claims involving $2,500 or less, civil cases involving $5,000 or less, voluntary and involuntary mental commitments, and domestic abuse. Steins was elected sheriff in 2018 and reelected in 2022. Now, what would make a career police officer, the elected sheriff, go and shoot a judge? Now, you have to be very careful about this, but there are allegations. A lot of people are saying there is no motive. We don't know the motive. People have been speaking in the local community, and you take this for what it's worth, saying that there was perhaps an inappropriate relationship between the judge and the sheriff's minor daughter. More will be developed, I'm sure, and we'll see if that turns out to be exactly what took place here. But to think about it, what would make an elected police officer, sheriff, ruin his career, what appears to be completely aware of what he was doing and the consequences thereafter? It really makes you wonder. I don't know, kind of reminds me of that John Grisham novel, A Time to Kill, doesn't it? We'll have to wait and see. Next on the docket, Sarah Boone. That's right. Sarah Boone, the same lady accused of killing her boyfriend, and she's on her ninth attorney. Well, the ninth attorney has announced that he will be relying upon an argument of self-defense on her upcoming murder trial, and apparently it left the judge momentarily speechless. I'm a little surprised as well. So, as you may know, and if you don't, I'm going to tell you anyway, Ms. Boone is charged with the second-degree murder of her boyfriend, Jorge Torres Jr., who was found dead inside a zipped suitcase after a night of drinking at the couple's apartment. Now, like I said, James Owen, who stepped in as Boone's ninth attorney after she struggled to represent herself pro se, after she could not get along with anybody, and the judge had found that she had lost her right to receive counsel through the prolonged delays and the inability to get along with anybody. So anyway, the new attorney told the judge at the motions hearing yesterday, "We are using the battered spouse syndrome for the defense, not an accident." Anyway, like I said, the judge seemed a little shocked, paused, and says, "Are you claiming self-defense?" And the judge said, "Well, that's the first I've ever heard of that." To bolster the defense, the ninth defense attorney had asked the judge to force the state to declare the exact criminal acts it alleged Boone made, whether that being zipped into the suitcase or failing to take action to open the suitcase when Torres begged to come out. Now, the attorney for Miss Boone noted that this is a unique case because there is no firearm or item typically thought as a weapon. But the judge denied that request, saying the state's indictment is sufficient as it stands, and Boone and Torres had a violent relationship, from what we can tell, in the years before the death relating to the alleged beating of Miss Boone. There were several charges filed against Torres over the years for allegedly beating Miss Boone. We'll see how all that plays out. Now, like I said, Owens has retained apparently two experts to testify on behalf of Miss Boone, saying that she has suffered from battered spouses syndrome. One of who recently testified for Marcia Thompson, who was acquitted of murdering her husband based on the same defense. Prosecutors are trying to block Ms. Boone from using this defense at all. They claim that videos from police body-worn cameras at the scene after she called 911 and interrogations in the days following, Boone repeatedly told investigators that she had been having a fun night and that Torres had got into the suitcase as part of the game of hide and seek. Prosecutors suggest that proceeding with the defense would force Boone to have to take the stand to testify, which I believe they are correct, because she would have to say that she felt in danger of immediate danger of death or serious bodily injury. So the judge ultimately said he would allow the defense to use the battered spouse syndrome defense and even mention it in their opening statement. The order requires Boone to submit to an examination by an expert of the state's choosing no later than September 26. Be curious to see if they can get all that done before the start of the trial on October 7th. Ms. Boone may just get the continuance that she has been requesting. I don't know, ladies and gentlemen, not a big fan of battered women's syndrome. It's kind of like duress. They made me do it. Well, did you go to the police station? Did you do this? No, you did nothing until it was target of opportunity. And why is this bad? Now, Ms. Boone would have to testify to get the self-defense instruction and explain. She's then going to have to explain away why she lied to the police for this entire time. This may also explain why she could not get along with any of her previous 8 attorneys, because if this is what she wanted to run, they're like, this does not make any sense. It's not based in any law or fact of this case, and we're not doing it. Be careful, Mr. Owen. I've mentioned it before. I did a case once, pro bono, and it just turned out to be ugly. Now, I know Mr. Owen says that he's being paid, or will be paid, but I think he may have bitten off more than he can chew here. Now, Mr. Owen said, in addition to the normal dress out order to wear civilian clothes, he is also going to be asking that Ms. Boone be allowed to have makeup and do her hair for trial. Because after all, you've got to look good, right? You got to look good when you're on trial for self-defense of putting somebody into a suitcase, not letting him out when he begs to get out. I don't know. I think I like the accident defense a heck of a lot better, but that's just me. What do I know? Next, Karen Reed gets the ear of the highest court in Massachusetts. That's right. As we all know, Karen Reed stood trial in the spring for the second-degree murder of her boyfriend, Boston police officer John O'Keefe, but the case ended in a mistrial when the jury was unable to come to a unanimous verdict on any of the charges in the case. Now, in the days and weeks after the mistrial, both the defense and the prosecution were approached by people purporting to be jurors who said they actually had been unanimous on 2 counts. Those jurors said they had only been deadlocked on the charge of manslaughter, but wanted to acquit Reed of second-degree murder and leaving the scene of a deadly accident. Well, the judge denied the post-trial motion filed by Miss Reed's attorneys asking to dismiss the case based on double jeopardy, ruling that no verdict was issued, and therefore the judge said, there's nothing I can do. Sucks. Nobody asked the jury to basically be polled or asked if they were deadlocked on all counts or on some. Either way, the judge denied the case and said that she will stand trial in January. Then on September 11th, Miss Reed's attorneys filed a petition with the Supreme Judicial Court, the highest court in Massachusetts, requesting they overrule the trial court's judge's decision not to dismiss the 2 charges. Now, the petition reiterates Reed's position that a retrial would constitute double jeopardy. The filing also notes that after the initial filing, a motion for the charges to be dismissed, Reed's attorneys were contacted by 2 more jurors to corroborate the other accounts, bringing the total number of jurors who contacted the defense to 5. Now, on September 19th, Justice Dewar, Elizabeth Dewar, ruled that the case would be presented to the full bench, what's referred to as en banc, which is 6 justices and the Chief Justice. Miss Reed's team will have until September 25th to file a brief, and the Commonwealth has until October 16th in which to respond. No oral argument date has been set as of yet, but the court may set that as well in the future. You never know what a Supreme Court is going to do. They're either going to shut this down big time or say that it's just simply not fair because maybe Miss Reed's case is the cause celeb of the day. But I just don't see how you can say, well, Judge, we didn't do it. We didn't poll the jury. We didn't ask if they were unanimous or deadlocked in any of the counts. I just don't see how procedurally you can go back and basically change the rules of the game. I think it'll fail. I guess we'll wait and see to determine if I am correct or incorrect. All right, next on the docket, a death penalty case in South Carolina. Now, there's always last-minute issues and pleadings in the death penalty cases. And why should this case be any different? So Freddie Owens, he is set to die by lethal injection later today for killing a convenience store clerk, a woman by the name of Irene Graves in Greenville, South Carolina in 1997, during a robbery. Well, on Wednesday, his lawyers filed a statement from his co-defendant, a guy by the name of Stephen Golden, saying that Owens wasn't even at the store at the time when Miss Graves was killed. So is this a case of actual innocence? Well, Golden said that he had previously blamed Owens, who was 19 at the time, because he was high on cocaine and facing pressure from the police. He wrote in a statement, "I thought the real shooter or his associate might kill me if I named him to police. I am afraid of that, but Freddie was not there." Now, despite the claims made by Mr. Golden, the South Carolina Supreme Court has refused to step in and stop the execution of Owens, which is set by lethal injection. Now, the justices ruled on Thursday that Golden's statement wasn't enough to halt prison officials from executing Owens. The attorney for Mr. Owens said that South Carolina is on the verge of executing a man for a crime he did not commit. We will continue to advocate for Mr. Owens. Now, Golden had testified at Owens' trial, saying that prosecutors promised to consider his testimony in his favor, but still faced a death sentence or life in prison. He was eventually sentenced to 28 years behind bars, and he pled guilty to a lesser charge of voluntary manslaughter. Now, Golden said, "I'm coming forward now because I know Freddie's execution date is September 20th, and I don't want Freddie to be executed for something that he didn't do. This has weighed heavily on my mind, and I want to have a clear conscience." The prosecutor said the several other witnesses testified that Owens had been one of the men that pulled the trigger. Those witnesses had been friends of Owens who said he had bragged to them about killing Miss Graves, and his former girlfriend also testified that he confessed to the killing as well. So, we also know that less than 12 hours after he was convicted of the Graves murder, Mr. Owens also killed a fellow prisoner, a guy by the name of Christopher Brian Lee, in a jail cell after Lee allegedly revealed his cousin was on the jury that sentenced Owens to death. Now, prosecutors have argued that Golden's decision to change his story couldn't be trusted, and he has now admitted to lying under oath, showing that he can't be trusted. Now, if executed, Mr. Owens would be the first in the state of South Carolina in 13 years because the state was struggling to get the drugs needed for the lethal injection. The state added to their options for the death penalty is a firing squad option, and passed a shield law to keep much of the details of the execution private. Now, the state Supreme Court then cleared the way for the death chamber to reopen this summer. Now, Mr. Owens was given the choice of lethal injection, the electric chair, or a firing squad, opting instead for a lethal injection. Apparently left his fate up to his lawyers, arguing that his Muslim faith means he cannot take an active role in his own death. That's a new one to me. Anyway, I can see both sides. Is it worthy of investigation? Maybe. But the fact that the guy that is now changing his story had previously been testified in court under oath, and he said that Mr. Owens was the shooter, and then you have multiple other witnesses, and I just don't think that's enough. I think you're not going to be with us tomorrow, Mr. Owens. I'm sorry about that, but unfortunately, life is not always fair, and neither is the law. Next, let me give an example of how not to treat a roommate. Police in Colorado arrested 3 people and are looking for a 4th after they allegedly attacked and beat up their roommate before holding him captive for several hours. Deputies from the Jefferson County Sheriff's Office responded about 10 a.m. on Monday to the St. Anthony's Medical Center in Lakewood. That's a little suburb just to the west of Denver. Anyway, there was a 45-year-old man in the emergency room and was telling people of his horrible ordeal. He said that he had been tied up and beaten over for 14 hours by his roommates, according to the probable cause arrest affidavit. And he told the deputies that he had lived in the home for only a couple of weeks. Or he was in a bedroom in the basement of a house when he overheard his roommates, later identified as Jason Carlson, Cheryl Allen, and Jimmy Ray Smith, and another one by the name of Luke Anaya. And they were planning on attacking him, according to the man. He was first tried to crawl out of a window, but when that didn't work, he barricaded himself in the room by putting items in front of the door. But moments later, the men allegedly broke through the door and fired rock salt at him from some sort of airsoft type gun. Now, is that the rock salt thing that you shoot flies and mosquitoes with? I don't know. The whole thing sounds a little bizarre to me. Well, then the man says that the roommates began assaulting him. It's alleged that Mr. Smith put his boot on the victim's throat and applied enough pressure to cause him to lose consciousness, which is a second-degree assault here. Then the suspects allegedly bound him in a chair with zip ties and electrical tape, and after he was tied down, the roommates took turns whacking the victim's knees with a baseball bat. Then it's alleged that Mr. Carlson poured rubbing alcohol on the victim's face before lighting the liquid on fire. Apparently, the assault continued in the basement and upstairs until two other people came to the home and told the suspects to leave the roommate alone. He was driven to another house before someone else took him to the hospital. The man's injuries matched his story, and he had singed eyebrows, burns on his face, swollen and discolored knees, and a broken thyroid cartilage on his neck. There was also evidence that he had been tied down, according to the affidavit. But once again, no motive. Ladies and gentlemen, when they say in the press there is no motive, it means there's something weird. Kind of like the whole sheriff-judge shooting thing. We can't figure out any motive. I just don't know why. Okay, everybody else knows in the small town apparently, but they're not stating it. This one seems a little weird. My guess is the victim stole something of value that all the roommates were in on. Going on a limb here, but I think that's what's going to come out. Anyway, the victim ultimately gave the location of the assault and identified Mr. Carlson as the homeowner. The SWAT team arrested Mr. Carlson, Allen, and Naya, and they were all taken to jail where they remain in custody on bonds ranging from $150,000 to $300,000. Mr. Smith remains at large, and they are facing charges of attempted first-degree murder, kidnapping, and assault. There you go, ladies and gentlemen. You can't make this stuff up. And when they say they just don't know why they did it, that means there's something weird going on. All right, next on the docket, this day in legal history. Wait for it. On September 20th, 1633, we're going way back, the Roman Catholic Church tried Galileo Galilei on charges of heresy. Galileo was brought before the Congregation for the Doctrine of Faith for his assertion that the earth orbits the sun. He was sentenced to spend the rest of his life under house arrest. Now, Galileo has been called the father of observational astronomy, modern era classical physics, and the scientific method and modern science. There you go, ladies and gentlemen. He was apparently quite the guy back then, but apparently he was a man ahead of his time. And how dare he question anything that the people said was the truth? Can't do that now, can you? I think it is worth noting that Galileo later defended his views in the dialogue concerning the two-chief world system in 1632, which appeared to attack Pope Urban VIII and thus alienated both the Pope and the Jesuits, who had both supported Galileo up until that particular point. Like I said, he was tried by the Inquisition, found vehemently suspect of heresy, and forced to recant. He spent the rest of his life under this house arrest, and he wrote the two new sciences in 1638, primarily concerning the strength of materials. So at least he kept busy. Never stop learning, Galileo, even when you're under house arrest for the rest of your life. And finally, please meet our dumb criminal of the day. Please meet our dumb criminal of the day, Sean Uribe. Police allege that Mr. Uribe would follow female victims around Miami, Florida, department stores, and used a medical syringe to squirt an unknown liquid on the buttocks of the women's outfits. Now, while brandishing the syringe in one hand, Uribe was filming the acts in the other with his cell phone. And according to the police reports, Mr. Uribe squirted a juvenile in late June at the Ross Dress for Less store, and the girl told the police that the other shoppers alerted her that a man used a syringe to excrete an unknown liquid on her buttocks to be exact, and then started filming her. The suspect fled after the witnesses contacted store employees, and of course that was all captured on video surveillance. Last month, police began investigating a battery at a Marshall store that mirrored the June incident. The male suspect approached a woman from behind and used a syringe to spray an unknown substance on the victim's left buttocks area. The man, who appeared to be recording the victim, matched a physical description of the suspect in the earlier crime and was wearing a Miami Dolphins baseball hat. Well, the victim of the August 29th incident was in shock, and before she could confront the male, he walked away from her and out of the store. She later picked Uribe out of a photo lineup. Anyway, Uribe was arrested last week on a battery of a child, a felony, 2 misdemeanor battery counts, and a felony tampering with evidence charge. So this is where it gets good. Uribe posted bond and was subject to house arrest. The judge previously ordered him to stay away from the department stores. Well, during a post-arrest interview, Uribe confessed that the liquid in the syringe was Cetaphil, skin soap or something. He also claimed to have deleted all the videos from his phone. But while he was in custody, you know, those phones that are monitored, Uribe was allowed to use the phone to call his father. Now, during that conversation, which was recorded, Uribe directed his parents to go to the family residence where he had been staying and remove all of the hard drives. I need you to get them and effing hide them, he said. Put them under lock and key. But guess what? Mr. Uribe's father arrived at the residence after the police were already dispatched to secure the property. A search of the home turned up the hard drives in the exact location where Mr. Uribe told his father they would be. They also seized 3 medical syringes containing the viscous white liquid, consistent with that of semen, clothing, and other potential items for forensic evidence. Police are reviewing the confiscated hard drive contents, which could result in additional charges. Mr. Uribe, you are a dumb criminal of the day, not only for being some sort of weird pervert that goes around squirting soap onto young ladies behind from the syringe and recording it, but if you watched Crime Talk, you would know those calls from the police station, the jail, are all recorded. And in this particular case, once again, the defendant's own words are the ones that bring them down. That's all we have for today, ladies and gentlemen. Thanks for watching. Hope you enjoyed the show. Have a wonderful weekend, and we'll see you next time on Crime Talk. But never forget, and always remember, the Constitution matters.